Hi everyone, I'm Jen. I'm a lawyer in the employment team at Brown Jacobson. I'm going to talk to you today about the Employment Rights Act. Just a quick check in the room. How are people familiar with the Act? Have people kind of got a general idea? I'm sure there's kind of a range in the room in terms of what people know, and there is a lot to it. So what I'm going to do today is just run through a headline summary of the Act, of the kind of key provisions. I'm not going to go through everything because there just simply isn't time. So I've picked out what I think are going to be the key points, the points that are going to have probably the biggest impact on the most organisations. But if there's anything that I touch on briefly or that you'd like more information about, then please come and find me at the end, and happy to have a chat. So just before we get started on the content. The Employment Rights Act is the biggest overhaul of employment rights in a generation. It's absolutely massive. It really kind of goes to the heart of the employment relationship and the way that employers will interact with their employees. It's part of the Labour government's plan to make work pay, which you may have heard about, and really you'll see as we go through that the whole purpose of the Act and the provisions within it are really to strengthen workers' rights, workers' security, and workers' ability to take action when they've been treated unfairly. There's also a lot in there about avoiding exploitation of workers, which has been a big focus of successive governments as to how to stop that happening. So this is kind of the fruit of all of those labours. But for employers, understandably, there are elements of it which are concerning. For employment lawyers, there are also elements of it which are quite concerning because of if any of you have been involved in employment tribunal cases recently, or businesses or organisations have, you'll know just how much the tribunal system is struggling with the caseload that it already has. So you could be waiting, up to 2 years or more for your case to end up in front of a tribunal. As you'll see, the provisions that we're going to talk through today, from our perspective as lawyers, we don't see how the current tribunal system is going to be able to handle what could lead to quite an increase in cases. So it's kind of a case of watch this space. The other thing to note about the Act in general is that whilst we have the Employment Rights Act, a lot of the provisions that we're going to talk through, we don't have really the detail about how they're going to work in practice, because a lot of them will rely on secondary legislation, which hasn't been published yet. So rather unhelpfully throughout this talk, I will be saying we don't know how this is going to work. We're not sure what the details are. We are obviously keeping an eye on that, and things are coming out quite regularly. But for the moment, particularly for some of the bigger changes that are coming in, we simply don't have the detail as to how it's actually going to work in practice, which is quite difficult and again concerning, given that a lot of these changes are due to come in. Some have already come in, some are due to come in end of this year, towards the end of this year, and some through 2027. So there's just some key points to be mindful of while we go through. So I've just realised I'm quite short. I'm not sure if you can see me over this table, but so unfair dismissal rights. Currently, to bring a claim for unfair dismissal, in most circumstances, you need to have 2 years service with your employer. The government originally made a manifesto commitment to offer all employees day one protection from unfair dismissal, which was met with some alarm. And that the Act as originally drafted did have that provision in it, but as it went through Parliament in the various stages, that was watered down. And now, following House of Lords opposition, the final position on that was that employees will get unfair dismissal rights from 6 months of service. That's obviously quite a change. And currently, for years, we've had that 2-year period where, if you have a new employee that joins your organisation and things aren't quite working out, you've got a bit of time to figure out, okay, is there something we can do about this, or to take advice. If someone's got maybe health concerns or a disability, you've got the time to involve occupational health, etc., before you have to make a decision, and you've still got that 2-year period before the risk becomes of unfair dismissal materialises. That's obviously now going to be a much shorter period of time. So 6 months goes by in a flash. It's the length of most companies' probation periods for new employees. So it really is a massive change in terms of risk profile for employing people. The other big change on unfair dismissal is the removal of the compensatory cap on awards for unfair dismissal. So for ordinary unfair dismissal claims that don't involve elements of discrimination or whistleblowing, there is a cap on the amount of compensation that an employee can receive, and it's set at the lower of just over £118,000 or 52 weeks pay. The Employment Rights Act is repealing that cap, so there will no longer be a cap on unfair dismissal claims. There has been an impact assessment done on this because understandably it was met with some concern as to how it's going to work in practice, and some employers felt that it was an unfair shift in the law. But the government has confirmed that the changes will come into force from the 1st of January 2027. So all employees with 6 months service as at the 1st of January 2027 will have that unfair dismissal right. We're not sure exactly when the change is going to come into place in terms of the removal of the cap on compensation. We expect it will be, again, only for dismissals that occur after the 1st of January, but that's not been confirmed yet. In terms of what that means for employers, so in terms of the reduction of the qualifying period, it really means that recruitment practices are going to become more and more important because you don't have that same length of time to figure out if someone's capable of doing the job that you've hired them to do. So it's about looking at, are your recruitment practices robust enough? Are you screening people properly? Do you need to maybe enhance those recruitment processes to make sure you're getting the right people in the door because you don't have the time after they've started to make that assessment in the same way? The other thing is probationary periods, which I've mentioned. Most probationary periods are 6 months, so you don't really sit down and look at someone's, or a lot of employers don't sit down and look at someone's performance until the end of that 6-month period. From January next year, that's going to be too late from an unfair dismissal perspective. So consider shortening probation periods to 3 months possibly, or having them 6 months, but with a very clear 3-month review. And making sure that the management of that probation period is done really carefully and closely so that any issues are picked up really quickly. Removal of the cap, and obviously removal of the cap only really applies to higher earners, but it is a concern in those cases where you have an employee who is senior or has a remuneration package that is quite generous. Because currently in those circumstances, if we're negotiating an exit for someone, we're able to say, well, if you were to take your employer to a tribunal and bring an unfair dismissal claim, the absolute maximum you could possibly get would be £118,000, and that might be in 2.5 years' time. But we've got a deal on the table here which allows you to walk away now with this amount in your pocket, and usually there's a deal to be done there. What the removal of the cap means, though, is that conversation no longer carries the same weight as a negotiation tactic, because if you're a senior exec, for example, you've got a salary that might be in the hundreds of thousands, you've got an annual bonus that might be 50% of that, you might have equity that if you get sacked, you lose that. All of those things combine to mean that it's potentially much more attractive for them to bide their time and go to an employment tribunal. So we'll have to think a lot more about, in those circumstances, how those negotiations happen, and that's something to bear in mind. And if you are looking at any potential exits, or if you've got employees that aren't performing, it's about kind of keeping in mind that 1st of January date. The next significant changes, the changes to the rules around fire and rehire. So fire and rehire is when you, just to recap, is when you want to change your employee's terms and conditions. You need their consent to that. The employee won't consent, so you dismiss them and you immediately offer to re-engage them on the new terms. The government initially proposed to make that automatically unfair. So if you do that, whether or not you follow what you think is a reasonable process, it will automatically be unfair to do it. The provisions have been watered down in the final version of the Act, so it now only covers certain restricted variations, so reductions to pay, holiday entitlement, working hours, and pensions. So if you're changing someone's workplace location, for example, and they don't want to agree to it, potentially foreign rehire is still a viable option for you, but you have to still do it fairly, of course. You can't use a general variation clause in a contract, an employment contract, to vary someone's contract and to get around these foreign rehire rules as well. So that's something to bear in mind. Those reforms are expected to take place in January of 2027, so the same time as the unfair dismissal reforms. It's a significant change to the current law, and foreign rehire at the moment, although it is quite a risky option, is something that we do commonly see used. We think that's going to become a much less attractive option for employers. So if you're looking at changing terms and conditions, again, keep an eye on that 1st of January date, because it will become much more difficult and much riskier after that point. Collective redundancy rights. So currently, if you're proposing to make redundant more than 20 employees at one establishment within a 90-day period, you have to collectively consult. So there's an enhanced consultation process you have to go through, which includes notifying the Secretary of State. And there are prescribed periods for how long that consultation needs to be, depending on how many employees we're talking about. The changes to the rules here it's one of those areas where we don't have the specificity in terms of the detail, but essentially they're changing the threshold at which that collective consultation obligation will be triggered. So it will be 20 or more employees at one establishment, or at least the threshold number of employees, which is to be defined in further regulations. So we don't know what that's going to be, but it could be it could be a different number. It could significantly change collective consultation rights. The government have said they will issue guidance to help employers comply with these new requirements, and we're waiting to see what that guidance might be. The other important thing to bear in mind in terms of redundancies, so for failure to collectively consult, employees can apply for a protective award. It's currently capped at 90 days pay, but under the new legislation, it's going to increase to 180 days pay as a maximum. So that's obviously a significant increase in the amount of that award. So in terms of what that means for employers, depending on the threshold number, it's potentially a big change, and it would mean that the obligation to consult at collective level is triggered far more frequently than it is currently. And that's quite a burden on employers, because it's a much more stringent process that needs to be followed than individual consultation. And the financial penalties in terms of breaching those collective consultation rights are higher. Sometimes employers take a bit of a risk around not properly collectively consulting, because the protective award is currently capped at 90 days, but once that increases, that becomes a less attractive option. And then the next kind of set of changes, which I think this is the one where more than any other, really, we don't have really any detail on how these are expected to work. And actually, when you look at them in practice, it seems very difficult to understand how this is going to be enforced, how employers are meant to comply with this. But these are the changes to 0 and low hours contracts. And again, this fits into the whole aim of the legislation, which is to protect workers, to provide them with security, to make sure no one's being exploited. So these changes apply, as I said, to qualifying workers who are workers with minimum hours or 0-hour contracts. Where someone is on one of those contracts, an employer will have a duty to offer them guaranteed hours, which is based on the hours they've worked in a previous reference period. The length of that reference period, we don't know what it is yet, so we'll find out hopefully soon. But if you've got someone on a 0-hours contract that's been working for you for a period of time, they will have a right to request guaranteed hours, and you have to consider that and offer offer those guaranteed hours based on what they've been working. There's also new rights for 0 hours workers and minimum hours workers to be given a minimum level of notification of shifts and of shift changes. So you can't cancel shifts at the last minute. If you need someone to work, you have to give them a certain level of notice. Once again, we don't know what that notification is going to look like, what that period's going to be, but that is a significant shift, and workers will be able to bring claims for financial loss arising from breaches of those new rights. They'll also be protected from detriment for trying to exercise those rights. The reforms, again, are expected to take place in 2027, so there's a bit of time. The difficulty being, though, we don't know anywhere near enough detail at the moment to be able to advise fully on what, exactly what steps employers will need to take. This is going to be a particular issue for organisations that use casual labour, particularly kind of in the retail sector, potentially, if you've got seasonal workers, in social care sectors or in the healthcare sector, where you might have bank workers who work regular shifts for you. So it's and also these rules apply to agencies as well, agency workers. So that opens up a whole load of issues for kind of the recruitment and the employment business sector too. So it really is a massive change. And there is a school of thought that the government have kind of overcorrected here in terms of the provisions they put in place for 0 hours and minimum hours workers. Obviously, they are a group that have been, or they are contracts that have been used to exploit people in the past, and it's right that isn't allowed to happen and that steps are put in place. But actually, this is going to be incredibly onerous on employers and make that potentially not a viable option or model anymore. And then protection from harassment. So employers will now be directly liable for failing to prevent third-party harassment. So that means harassment of your employees by customers, by suppliers, by anyone they come into contact with as part of their role. That protection covers all types of harassment. So whether that be sexual harassment or harassment based on age or based on race, ethnicity, any of the protected characteristics. There's also a new duty for employers to prevent sexual harassment. That duty came in October 2024, and that duty was to take reasonable steps to prevent sexual harassment. That's been upgraded to a duty to take all reasonable steps. So that is obviously a much higher threshold and level of obligation on employers. There's going to be regulations that outline specific considerations and rules around this. But that, again, it follows along this line of making sure, of the government trying to make sure that employees are properly protected in the workplace. But it's a fairly onerous obligation on employers, and it means that you're going to have to look at supply chain. If you've got suppliers that are interacting with your own employees, what are their standards? How are they behaving? When you've got customers interacting with your employees, are you clear with your customers as to what's expected of them in terms of interaction, and what steps are you putting in place to protect your staff? And then this is just a list of some of the other changes, which I'll run through quite quickly because I'm not sure at the moment. So there'll be a tightening of rules around the use of NDAs. So NDAs which cover harassment and discrimination at work will be banned in employment agreements, with some exceptions. We've been, for quite some time now, when we advise clients on the use of NDAs, we are very careful with clients using those in cases where there has been harassment, discrimination, because there have been some really high profile cases involving those. But this is a kind of an outright ban on that. And it's obviously with the aim of preventing employers using NDAs to silence workers around misconduct. The next kind of group of changes is to trade union and trade union reforms. there's going to be reforms to simplify the process of recognising a trade union, and also processes for simplifying the process that needs to be gone through to take strike action, which basically will make it a simpler process for employees to strike and to ballot. A lot of those changes, by the way, just in terms of trade union reform, are already in place. So if that is relevant to your organisation and you want to have a chat about it, just come and see me at the end. But it's important to be aware of that. There's going to be what's called the Fair Work Agency. It's going to be established. That's going to be a new state enforcement agency. It's been set up, but it's not fully operational yet. And it's going to have really wide-ranging powers. So it has the power to bring ET proceedings against employers if it thinks that employers aren't doing what they're supposed to be doing. It can provide legal assistance to employees in proceedings, and it can recover costs of its enforcement activities. So it's quite a wide range. It's, again, not entirely clear what it will be doing on a day-to-day basis, but potentially it's quite wide-ranging enforcement powers. Flexible working requests. It's already a day one right for employees to be able to make flexible working requests. But currently, all an employer has to show is that it's followed a fair process and that it's refused the request on one of the 8 specified grounds. Under the new changes, the employers has to show that it's reasonable for them to have refused the request, which is quite a step change from the current position, because tribunals will, at the moment, accept if an employer says we followed a process and we can't do it because of this statutory reason, the tribunal won't really look into that too much. But now that test of reasonableness is going to apply, and the employer will have to explain why it believed the ground, but why it believes the ground of refusal is applicable. There'll be changes to family leave. So strengthening of protection against dismissal for employees who are pregnant or returning from maternity leave. The government has stated that it plans to make it automatically unfair to dismiss a pregnant employee or a new mother until she's been back at work for at least 6 months, which is quite a change in the position. The detail, again, of how that will operate in practice is going to be contained in regulations, which we don't have yet. There'll also be protection from dismissal for people returning from other types of statutory leave, so shared parental leave, paternity leave, bereavement leave. Paternity leave and parental leave will become a day one right, and bereavement leave, statutory bereavement leave, will be extended so that it applies not just on the death of a child, but on the death of spouses and other close family members as well. Employers will have to publish, employers with over 250 employees will have to publish an equality action plan. So similar to having to publish gender pay gap information, employers will have to publish this plan, which sets out the steps that they're taking to address gender equality in the workplace, including how they're addressing the gender pay gap and supporting employees going through the menopause. So again, that is potentially, it's a new obligation, and it's potentially quite a lot of work for employers in terms of the amount of time that's going to have to go into pulling that report together on top of the gender pay gap reporting obligations. And then finally, there are some public sector education and social care specific changes that are coming into force. I'm not going to go through them now, but if they're relevant to you and you'd like to know more, then please come and speak to me. So next steps is kind of most of the provisions, as I said, they've started to come into force this month. There are consultations ongoing, so if you're interested in any particular topic, have a look and see if there are consultations that you can get involved in. Implementation is in 3 phases, so April 2026, October 2026, and then 2027 generally as a whole. But a lot of the major ones are 1st of January 27. And then just some top tips in terms of what you can be doing. Obviously, in many of the areas, there's a limit to what you can do at the moment because we don't have the detail, but it's reviewing policies, procedures, training. If you use a lot of 0 hours, low hours workers, audit that use to see if there are any kind of pinch points. Consider the risk of harassment in your organisation. What have you got in place to prevent that? update existing family leave policies, etc. Look at your recruitment, look at your probation periods, and come and speak to us if there's anything in particular that you're concerned about.